Our talkback lawyer David Whiting is here to help you with free legal advice. 1300 222 774 if you'd like some free legal advice. 1300 222 774 is the number if you'd like to ask David a question. Good morning to you, David.
Good morning, John.
A couple of legal things around. First of all, as we discovered this morning, the Labor government, the Andrews State Labor government, are introducing a new system whereby some prisoners deemed too likely to reoffend to warrant being released at the end of their sentence can be sent back to court to effectively be detained maybe forever or certainly for periods of time, 2-3 years at a time, after the judge said they've done their time. What do you make of this system?
Well, we have a similar provision for sex offenders.
Yes.
And I must say that felt uncomfortable with that. I feel uncomfortable with this as well. If it's it's a penalty, you've done your time. You've got a parole period during which they've got much tighter controls over you with a view to getting you to behave and, in a sense, settle back into the community. It just scares me. And then you add on that the extra one that says, well, we now want to be able to do arbitrary and capricious 7-day detentions. We want to be able to lock you up for 7 days without a reason and presumably without review, John.
Gary David was the first person in Victoria to whom these laws were created. In about 1987, if I remember correctly, he was regarded as too dangerous to be released. He was a man who had committed many violent crimes but also self-mutilated, and at the time it was thought necessary to have him reviewed each year by a Supreme Court judge as to whether or not his condition had improved to the point where he could be released. He was several times ordered to be continually detained for another year and then another year and then another year. Eventually his health deteriorated and he died in jail. At the time we were told there's only ever exceptional cases.
Yes, we don't anticipate there'll ever be another one.
And then there's another one and another one, and now there's a whole category of prisoners who are too dangerous to be released.
Yeah.
Well, this is being hailed by, in particular, those on the law and order side of the debate as a great breakthrough.
I'm sure it is. It's the breakthrough against the wall of civil liberties, I would have thought. You assess the penalty, you do the penalty. I suppose, John, the law is designed on the assumption that with very few exemptions, people will obey the law and comply with their obligations as a member of the community.
Yep.
Is the issue that the range of what's acceptable and not acceptable is in fact moving? But it seems to me that the papers are full of people who appear to be doing weird things that just don't accord with what I consider to be acceptable behaviour.
Yes.
But I'm a bit terrified about locking them up indefinitely.
Well, that's certainly where the political climate is taking it.
And particularly we want to park them in Ararat, which is about as inconvenient to get to as possible. Oh, well, that nice place, but it
doesn't trouble too many people, I don't think.
No, just the people who have to visit the people who are locked up there.
Interestingly, in rural Victoria, I think it's Bendigo, there's an injunction has been taken out by a woman over the sale of a house. She had a judgment against her for a substantial sum, some hundreds of thousands of dollars. The sheriff was selling up her home to satisfy the debt, and she's got an injunction to stop the sale going ahead. What's this about?
Here's the process. We've had a couple of calls this side of Christmas that talked about enforcement by the sheriff. One of the last things that a sheriff can do is sell your interest in real estate. And in this particular case, there was I think the property was on the market listed for sale for about $750,000.
Correct.
Through an agent. The valuer general does a drive-by or curbside valuation and estimated about $487,000. And the property was...
the curbside was $475,000.
$475,000, and then what happens is the sheriff conducts an auction.
Yep.
The sheriff advertises the auctions in the Government Gazette, and as far as I know, nowhere else, or perhaps the sheriff's website. And you turn up at an office in the city, there is an auction, you pay your deposit, and then the sale proceeds.
Now, that's an auction on a weekday.
Yes.
In the morning,
yes.
In the city for a property, in this case, that was in Bendigo.
Yeah, Kennington, Bendigo.
So not a lot of people attend those auctions.
No, because they're unconditional. As a general proposition, you don't have the ability to view the property. You've got no idea what the mortgage is. So if there's a mortgage on the property, you buy subject to the mortgage. And the sheriff puts a reserve on this. Now, I would have thought that the reserve ought to be at least what the valuer general thinks it needs to be. In this case, the reserve put by the sheriff was substantially lower than that.
So the property sold to a bidder for $387,000, even though it was for sale for $750,000. But that was to satisfy a debt that the sheriff was trying to collect, which was just a fraction underneath the price they sold the house for.
I don't see any link between the two. It's possible for the sheriff to sell for less than the judgment debt.
If that's the best offer they're getting.
No. The sheriff's auctions, there are two types of sheriff's auctions. There are sheriff's auction with a reserve and the sheriff's auction without a reserve.
But they conduct it as like you're in the room and you're bidding against other people in the room.
Maybe, yeah.
Okay.
There may be players, there may not be players.
So the injunction here, it's interesting. The woman whose house is being sold is a city councillor, and my understanding is it's the woman who was heavily involved in the campaign to try and stop a mosque being built.
Oh, okay. Well, all I got was the newspaper article, and I've actually had a sheriff's auction where we didn't get a bid. And
apparently some of the amounts owing in the sheriff's debt may well be due to her campaign to try and stop the mosque and costs that were ordered to be paid as part of the campaign to try and stop the mosque being built.
Well, it would be a single judgment, John. It wouldn't be. You wouldn't combine judgments for the purpose of an auction. There would be a single judgment creditor. That might be costs. I don't know what it is. But I'm amazed that the sheriff set an auction that was an auction reserve that was in fact $100,000 less than the valuer general put as the bare bones value of the price without looking at it.
And half the value of what it was for sale for on the market.
Yes.
Either way, it's interesting. We put in calls to the councillor and she has not responded to us. We've spoken to our colleagues in the local ABC and we have at some stage been provided with a bit of information, but not a lot more detail. So, okay, I'm just getting a message on the screen. She has responded but can't speak on the radio. So there we are. She has got back in touch with us, but not to the point where she'll agree to an interview. So it's certainly fascinating to see someone's actually challenging the system.
Yes.
We'll see where that goes. Any other news before we move on?
High Court decided last week about what constitutes a retail premises. Now, this is a case that's been running through the Victorian courts. We started at VCAT, we went to the court, then we went to the Court of Appeal. We're now at the High Court, and it involves a cold store.
A
cold store, one of these huge boxes.
Cold store.
No,
cold
perhaps
store.
If you're there long enough.
Yeah.
A cold store that stored goods for people that were then given to retailers.
Right.
Or to people for whom they were stored. And the question that where it becomes important is that in a retail tenancy, a retail lease, the landlord has to bear the land tax so that the value of the land tax is incorporated in the rent figure as opposed to separate from it.
Right.
Lots of commercial premises are let on what's called a net rent basis. So you pay me as the landlord the rent and you pay these outgoings.
Yep.
Land tax is not a recoverable outgoing under a retail tenancy. So the question is a cold store a retail tenancy? And
why wouldn't it be?
Because the assumption is that the people you're selling to are using those items to on-sell to provide to other people. It's seen as being a wholesale process.
Not a retail process.
Not as a retail process.
Okay.
So the question that the court had to decide was, in terms of the definitions in the lease and in the Act, is this a retail premises? VCAT said no, it wasn't. Every judge along the way has said that it is. So, and there are now situations where if you are a tenant of a retail premises and you've been paying land tax and in circumstances where you're a retail tenancy, you can have your money back. You can get a refund. So that's going to make a difference.
All right.
And I have one, John.
Yes.
The Quebec Bar Association is seeking a declaratory judgment in Canada that all of the province's laws, regulations and decrees are unconstitutional.
All of them?
All of them, because they have not been adopted in both French and English.
Yes, love
in
it.
Quebec, they adopt them in French and then provide a translation, whereas there ought to be a simultaneous adoption in French and English.
So the legislation should be enacted in both languages.
Bilingually,
not
rather
in English
than,
and then later translated.
Yes.
That would be
Except,
extraordinary.
John, they do it in French and then don't translate it.
No, absolutely.
Yes,
All right, text message from someone who anonymously says, I used to work in the sheriff's office for years. Most of the officers executing warrants take the easy way out, whatever that means. Richard in Viewbank, good morning to you, Richard.
Hi there.
Well, Richard.
My question is about swimming pool fences. So I went to look at a house the other day and had no fence around the swimming pool. So I said to the agent, what's the story with this? And he said, Richard, everything will be done to make sure it's compliant before handover. I said, okay. And then a week later, we looked on the contract and the contract said, this pool hasn't got a fence, we're not putting one in, you agree to buy it like that.
Yes.
Now, is that legal?
Yes.
It
is
is.
the short answer. Houses are required to have smoke alarms, and if they've got a swimming pool, pool fences. The standard terms of the contract of sale saying you're buying what's there, and it also goes on to say that if council slaps a notice on it the day after you buy it that requires the construction of a pool fence, that becomes your issue.
Okay. And what time frame would you have to put this fence in?
It will depend upon what the order says. Now, my view is the order might be for a pool fence, there would be a requirement to make safe, which might be temporary fencing, and then there would be a requirement for a permanent fence, and you might get 30 or 60 days, but you wouldn't get a very long period of time.
Sure. Okay. Thank you.
Thanks.
Hope that helps you. Emma in Fitzroy. Morning to you, Emma.
Oh, hi, John.
Hi, Emma. How can we help you?
Hi, David. Hi. I'm listening. I've got a girlfriend of mine who's going through a court process at the moment with an ex-husband. She can't ring because there's another court. She's got another court hearing coming up in the magistrate's court.
Yeah.
She's separated from her partner 7 years ago. Was an abusive relationship, and so currently for the last 7 years she's been dragged through the courts, magistrate court and the federal court.
When you say the magistrates' court, do you mean the state magistrates' court?
Oh, yeah. So
because there was a federal magistrates' court, which is now the federal circuit court.
Oh, okay. I'm not certain. So it's in the last 7 years. I'm not sure of the specifics. But he was ordered to sell the house by the magistrates' court.
Yeah, then that will be the circuit court. Yes.
Yep, he didn't do it. Yep. So then went to the federal court and then ordered to sell the house.
So he would have appealed then, yes?
Yeah, yep. But she had to get lawyers for both those hearings.
Yeah, it can be very annoying.
Expensive.
And still with no settlement money. So anyway, she's done that and been ordered the house being sold. She has a settlement. She has the money, but then wasn't taken off the mortgage. So now she's got can I say the name of the bank?
No, you don't need to. Doesn't make any difference, so don't.
Okay. So bank still today has not discharged her from the mortgage.
But I'm sorry, has the property been sold?
Yes.
Then the bank will have been paid out when settlement occurred.
Yeah. So but there
might be a credit card debt. There might be something else.
There was an overdraft, and there was.
Yes, I understand that, and it may well be that that may not have been secured by the mortgage, but she'd promised. Yes.
The actual main thing I'm ringing about is though that he has been allowed. She's for 7 years constantly, a few times a year, been dragged into court over small matters like, that he wants to change to have more, have custody of the children, full custody or shared custody.
And which one of those rights do you want to take away from him, Emma?
Not that she wants to necessarily take it away because he asked for these things.
She doesn't want her to do anything about it, doesn't want her to have those rights.
No. Well, the thing is he asked for that and she agrees to it. And then he doesn't do it. He doesn't have the kids on those days, or he doesn't. What he insists on having in court, he then has no intention, and he doesn't. Follow what he was supposed to. But then
Emma, there's no doubt there are people who manipulate and abuse the system.
Yeah, well, this is why I'm ringing, and I don't understand why. And now she's got lawyers that she has to pay lawyers, and she's been told to get a clear.
Do you not understand why or how is the very big difference? I mean, if we go into why, then that comes down to psychology and
Absolutely.
emotion.
Yeah,
but if
so-
you're talking about how rather than why, the system, David, confers certain rights on people, and in order to strike a balance to make sure that people can get a good outcome, sometimes it leaves a few weaknesses, dare I say, in the system.
Emma, the
Dream,
problem.
I just-
So the problem is that the system is built around the community at large, and not your friend.
I understand.
So the result will
But I'm
be.
going through this myself, but I'm sort of quite in control because I was fortunate that my husband actually physically assaulted me. So I kind of
You were
am in a
fortunate.
better...
I wouldn't call that
Yeah,
fortunate.
no,
Emma.
actually I am, because it means that I've had police involved and they can do things.
Okay. Either
So
way,
it's
yes,
helpful,
the system.
but she hasn't had that, and now
Okay.
she's sort of stuck in and out of court all the time. So do I need to go to our local member, or...
Well, if you go to your local member, what are you going to do? Ask the member to change the law, or tell the judge not to rule in a particular way?
The system is imperfect. There's no doubt about that.
Unfortunately can't raise her children properly. Like, she's left going in and out of court while she has a full-time job.
Well, I don't know the details, nor does David, but
No,
Emma, you
of
have to.
course not.
Sometimes you have to fight fire with fire.
Yeah.
Sometimes you do, and if people
Well,
want
I
to
thought
scorched
maybe a
earth,
private investigator might be
well,
more
if people want a
useful.
scorched earth approach to family litigation, regardless of the impact on the kids, sometimes there's just nothing you can do about it, and you have to say, well, if that's how you want your kids to think of you and remember you, you go right ahead. But I'm not rolling over here, and.
I mean, the sad thing is, it's not that what the children think; it's that the children are so affected by mum being so scared.
Of course they are.
And I see the effect it has on the children, and it's just not right.
No, it's not. But
then what you've got is the opportunity to make a submission, if you like, to the Commonwealth Government's review into family law matters, and see if you can look at it that way.
No, I think Emma's looking for
an
a
imperfect
circuit
system.
Emma's looking for a circuit breaker, and there aren't any, are there?
No.
I mean, there just are people, and the courts are full of them, who manipulate the system, hoping to get something to their advantage.
Yep.
Sometimes they do, sometimes they don't. Sorry, Emma, that's not really what you wanted to hear, I suppose, but it's extremely frustrating, I agree. David in Belmont. Hello, David.
I'm on in there, John.
Hi, David.
Yeah, David, I need to, and I'm very honoured to because I listen to you all the time, you know what I mean? I need to know about my right to hold the union ticket. I'm a prominent trade unionist. I'm a founder member of the
Union?
Maritime Union.
Yes.
And I'm a founder member of the Victorian branch of the CFMU.
So is this an employer problem or a union problem,
Both.
David?
Both.
So does the union doesn't want you to hold the ticket?
Well, they've refused my entry into the union meetings, and
Are you a member of the union?
I've been a member of.
No, I didn't ask have you
Yes,
been. I'm
yes.
asking are you?
Well, they're refusing my right to pay for my union ticket.
And a union is like an association or a company. It has a set of rules.
Yep.
And there will be rules relating to the admission of members, and there will be rules that relate to the getting rid of or excluding members.
Yeah, well, I've been excluded.
Right. And what does the Constitution of the Union say about your review or appeal rights?
Well, I moved at the last...
No, David, I'm not. We've
I'm asking
named the
you-
union, which is mildly unfair to them, but only mildly.
Yeah.
And I don't know. I'm not in a position where I can stand in judgment as to whether they acted appropriately or not.
That's right.
What have you done in terms of your review rights?
I went to a lawyer, okay?
But there will be an appeal process. What have you
Yes.
done in the appeal process?
I apologise for moving an amendment, which I at a mass meeting. I did not know that moving an amendment was against the. I should have opposed the motion, but I moved an amendment.
Yes.
So, I've been a long term,
A long-term unionist, but not a unionist in a political sense.
Well, a very political sense.
Yeah.
I was.
David, your issue with the union is resolved in the constituent documents of the union.
Within the rules of the union.
The rules of the union. There will be a process, and you're stuck. I mean, you don't have the right to join an association. Well, sometimes you do and sometimes you don't, but there's no automatic right to join any organisation that you want. You have to meet their eligibility requirements.
But if they want to expel someone, they've got to go through the right process
There is a long
too.
process.
All right, David. So, I mean, is your lawyer independent of the union?
Well, see, I can't go through Slater and Gordon because they're
they act for the union.
David, is your lawyer independent of the union?
Yes, but I couldn't. I couldn't afford.
That's the difficulty. But then that's like anyone else.
Yeah. So I was told to go to phone a certain number, which was it's called employment and employment.
So it was a helpline for employment, was it?
I actually phoned Morris Blackburn and they put me onto it.
Okay, well, David, those are the options, are they not, for David Whiting, for David from Belmont?
Yep.
The rules of the union are what apply.
So you need to get a copy of the rules of the union and look at what your rights are in terms of expulsion or suspension.
And if you need a lawyer, it can't be the lawyer who's also acting for the union, so it's got to be someone independent. And if another lawyer is prepared to do it for nothing, that's good. But if you have to pay for them, then like anyone else in a dispute, you have to pay for them. They're not going to do it for love.
No.
Sorry, David, that's probably not what you wanted to hear. That's as far as I think we can take it today. In Ferntree Gully, morning, Dave.
Morning, John and David. I'm ringing on behalf of my daughter and her husband who've bought a block of land on a subdivided golf course.
Yes.
Where it's on a slope.
Yes.
The contract stipulated that it would have 1 metre of fill to flatten the block.
Yes.
They've now taken possession and find that it's got over 3 metres of fill, which will lead to a hugely inflated
building costs will go berserk. Yep.
Mm-hmm. And wondering what they can do about it. I mean, as we see it, they've been sold something that they bought something that they didn't contract for.
John, there are some specific rights, and I will come back to you next week. Right, there are disclosure requirements in the Sale of Land Act for fill. I just need to look and see what the result is.
How long ago was the transaction concluded, Dave?
Only a month ago, John.
Is there a cooling off off the top of your head,
No,
Dave?
what will have happened is that Dave's daughter and son-in-law will have bought off the plan about 3 or 4 years ago. The development process has been completed. The plan's been registered.
Yep.
They've now settled.
On the subdivision.
And they've now called in a builder. And they've done a soil test.
And gone,
the soil tests, ouch. Yes.
Exactly. That's it.
All right, so
and those timelines are about right, are they, Dave?
Yes. It was about 2.5 years ago.
Yep.
But yes. Yep.
Okay. Now, when they bought the property, did they have a lawyer acting for them on the conveyance of the land?
John, that wouldn't have made any difference. There's a requirement that if there's fill, that the fill be disclosed. Now, they clearly knew that there was a metre of fill. They didn't know there was 3 metres of fill.
Well, I'm just wondering if there's... Let's have a look at it step by step.
Yep.
And there's also a due diligence argument, isn't there, on whether or not the right questions were asked of the right people and the right disclosures were made when those questions were asked.
Yeah, you'd wonder whether the fill was in before the contract was signed. I wouldn't have thought so.
Did the block change visibly between buying it and now, Dave?
Well, yes, because there were retaining walls and the land has been levelled.
Okay.
So yes, it has. But the contract clearly stipulated that it was a metre of fill.
Okay.
Understood. Next week, Dave.
Alrighty.
Good. Thanks.
We'll
very
get an
much.
answer for you at the start of next week's segment. Richard in Clayton. Hello, Richard. We've had a string of Daves and Davids. Good to have a Richard.
Hello there, John and David. How nice to hear from you again after all this time. David, I'll try and make this as quick as I can. It's just relatively a matter of removing a derelict car from the property where I am a tenant, where I live. And
how derelict is it, Richard?
Well, if you saw it, you'd say, well, there's no way known you'd get a roadworthy to drive that anywhere. And
so is it in, Richard, is it in the common property in a block of units, or is it in the house? Sorry, is it in the yard of a house?
Well, there are 2 parking areas with very limited parking spaces because the Department of Human Services, when this place was constructed, never thought a lot of elderly people would have motor cars, but more of them seem to have them now than
not. Yes.
Used to.
Does someone own the? We don't know who owns the car. It's just been dumped, has it?
I know who it is. It's a fellow tenant, if I can put it that way.
Is it still registered?
He claims he re-registered it.
Okay.
So
But
why
there are
can't
no
he have a
plates
car
on
that you
it.
don't like?
But there are
Why can't he have a car, David? Richard?
There are no plates on it.
No, but why can't he own the car and park it there?
Well, because it's denying us a space we could use. There's only 2 spaces in each area.
And how many? So is there an allocation of 1 space per residential living unit?
Well, the number, yeah.
No. I don't know what it is that you've leased or rented. Now, if you've leased or rented a unit and a car parking space, then I would be talking to the department and saying,
I have done that.
You've got to make sure I have access. But if all they've done is leased you a unit and then say there's potluck for parking, then I don't see that, that's, in a sense, that's an issue between him and the department. It might be grounds for a gripe, but it doesn't mean that they've taken away any of the rights you have.
Most importantly, though, Richard, what sort of car is it?
It's an old Triumph Vitesse.
A Triumph Vitesse?
Yes.
What have you got against the old Triumph?
Well, you ought to see it.
It's highly collectible.
Well, that may be the case, but he's been offered money by towaway wrecker people. They do take them at no cost to the owner.
He might be wanting to restore it and restore it back to its former
he
glory.
bought another one, but he's not in very good health, so I don't understand why he's doing those things, really.
Well, that's his business.
Huh?
That's his business. That might be what's keeping him going, the idea that he's going to get back to fixing up the old trumpet.
We are not. We're being denied that spot because it's
You
very
can't use the
limited.
spot, I understand that.
Yes.
But what you haven't told me, Richard, is whether you have a right to the spot. And in terms of you and the department or you and your landlord, that's the question. So I wish you luck, but I would be leaning much more harder on the tenant and find out whether the person who is, for want of a better word, offending, has a right to the spot he's occupying.
Good luck with the Triumph Vitesse, David. Lots of people saying in terms of family law, Emma from Fitzroy ringing about her friend who's been given the runaround. She says, at what point does someone become a vexatious litigant in family law? Does that ever happen? Does someone have their rights taken away because they abuse the process?
It does, but it's very rare. And the moment you bring a claim that involves children and you're making an accusation that, because the issue is what's in the best interest of the children, the court's going to hear it. So you're stuck. The court's not going to say, I'm not prepared to hear from you because I think you're a ratbag, even though you're raising an issue that needs to be addressed in relation to children.
And years ago, I knew of a case where a divorcing couple went to court over the spelling and pronunciation of the family name.
Oh, yeah, I could see that, yes.
Where it was anglicised by one of the parties to the marriage, and the other one said, you can't do that. And the children are not to follow that example and not to take the anglicised version of the name. It is to stick to its original version. And they went to court. They went and saw a judge. The judge was a bit cross and said, do I really need to spend my time on this? And they went, yes, this matters a great deal to us. Mm-hmm. And on it went. What do you do?
You hear it, John.
Well, you have to. Thank you.
Thank you. See you
Our
next week.
talkback lawyer, David Whiting, helping you with free legal advice. I'm sorry if you didn't get through. David will be back at the same time next week for more free legal advice.